Welcome to today's news topic. We're diving straight into a significant piece of legislation that's really shaping the future of artificial intelligence in Europe. The EU's Artificial Intelligence Act.
Exactly. And it's a really comprehensive piece of work. It sets up these different categories and rules for AI technologies right across the European Union.
Yeah, seems like a big deal.
It is. It's fundamentally about making sure we can actually benefit from AI while, tackling the risks involved.
Okay, so our goal today is to kind of break this down for you, our listeners. It doesn't matter what your technical background is. We want to get to the heart of what this act really means.
Yeah, and the way it works is basically by looking at risk.
Hmm.
I mean, different AI applications just come with different levels of potential harm, right?
Right.
So the Act puts rules in place that try to match those levels of risk. We'll be focusing mainly on the four main categories it defines.
Got it. Okay, let's start with the category where the stakes are, well, highest. Unacceptable rogue AI systems. These are the AI applications that are simply not allowed under this new law.
That's right. These are the ones considered to pose just too much of a threat to our fundamental rights, our safety, even our democratic values. The Act gives us a pretty clear list of what's in this prohibited zone.
Okay, so what kind of AI are we actually talking about here? What's being outright banned?
Well, first up, the Act prohibits AI that uses sneaky manipulative techniques, things designed to distort people's behavior in ways that could cause them significant harm, basically by messing with their ability to make informed choices.
So AI that's kind of subtly pulling the strings behind the scenes without us maybe even knowing, and it ends up hurting us.
Precisely. And similarly, AI that takes advantage of someone's vulnerabilities, maybe related to their age or if they have a disability or their socioeconomic situation to twist their behavior and cause significant harm, that's also on the banned list.
Right, protecting those who might be more easily influenced.
It's really about that.
That makes total sense. What else is a definite no-go?
Social scoring systems are a big one. AI that judges or classifies people based on their social behavior or personal traits.
Well, yeah.
And that can lead to them being treated unfairly or negatively. Like, imagine being denied a loan or a job because some AI didn't like your social media activity or something.
Wow, and AI essentially deciding your social worth, that's definitely something to be concerned about.
Absolutely. Also prohibited is AI that tries to figure out if someone's going to commit a crime just by looking at their profile or maybe their personality traits.
Just based on characteristics?
Yeah, but there's a really specific exception here. This isn't banned if it's part of a human assessment that's based on solid, verifiable facts directly linked to actual criminal behavior.
Okay, so the key is that the AI can't just make predictions based on, like, vague characteristics. It needs to be tied to actual evidence.
Exactly. Then the Act bans putting together facial recognition databases by just scraping images from the internet or maybe from CCTV without any specific target or reason.
That feels like a big step for privacy.
It definitely is.
What about those AI systems, you hear about them sometimes, that claim they can read your emotions?
Ah, yes. Those are also largely prohibited in workplaces and educational institutions. Now, the exception is if it's for specific medical or safety reasons.
Okay.
So you might see it in, say, very specific therapeutic situations, or maybe where detecting extreme distress could prevent an accident, but generally not allowed in those settings.
Right, so no AI boss trying to analyze your facial expressions during a performance review?
Not legally, no. Another prohibited area is biometric categorization systems. These are the ones that try to figure out sensitive things like your race, political opinions, trade union membership, sexual orientation. You get the idea.
Really personal stuff.
Exactly. Again, there are some narrow exceptions, like for lawfully acquired data sets when labeling or filtering data, and for law enforcement when categorizing biometric data in specific justified cases. But it's heavily restricted.
So the main idea is really to stop AI from just making assumptions about really personal aspects of who we are based purely on our biometric.
That's the core principle, yeah.
Yeah.
Finally, and this is a really sensitive one, we have real-time remote biometric identification, RBI, in publicly accessible spaces when used by law enforcement.
Right, I can imagine. What are the exceptions here? I know they're very specific.
There are three, and they are very tightly defined and controlled. The first is for targeted searches for specific victims. Think missing children, people abducted, victims of trafficking or sexual exploitation.
Okay, that sounds like a critical exception for really dire situations.
Absolutely. It recognizes that urgent need. The second exception is for preventing a specific, substantial, and immediate threat to someone's life or physical safety, or to prevent a foreseeable terrorist attack.
So imminent danger, basically.
Yeah, being able to act quickly. And the third exception,
What's the third?
it's for identifying suspects in serious crimes. The Act actually lists specific examples: murder, rape, armed robbery, serious drug trafficking, organized crime, environmental crime, things like that.
Okay, so a very specific, quite serious list of crimes. Now, there are also some significant rules around how even these exceptions can be used, aren't there?
Oh, absolutely. The use of real-time RBI must always be necessary and proportionate to the potential harm. Law enforcement has to really carefully consider if the benefit outweighs the impact on people's rights.
So they have to weigh it up.
They do. They have to think about how serious, how likely, and how widespread the harm is that they're trying to prevent.
And there's a whole process they need to follow before they can even think about using it.
Yes, generally. Before deploying real-time RDI, they usually need to do a fundamental rights impact assessment and register the system in an EU-wide database.
Usually.
Well, if there's a genuinely urgent situation, they can start deployment without immediate registration, but they have to register it as soon as possible afterwards.
Okay. And what about getting permission, like actual authorization?
That's another key safeguard. In most cases, they need authorization from a judge or an independent administrative body before they use it.
Before.
Again, if there's a truly urgent need to act immediately, they can deploy first, but crucially, they have to request that authorization within 24 hours.
And if it gets denied?
If that authorization is ultimately denied, they have to stop using the RBI right away and delete any data they collected.
Wow. That sounds like a really important system of checks and balances, especially given how powerful and potentially intrusive real-time biometric identification can be. Okay, so we've covered the unacceptable risk category, the things that are banned. Let's move on to high-risk AI systems. These aren't banned outright, but they come with a significant set of rules attached.
Exactly. An AI system gets classified as high risk in basically two main ways. First, if it's used as a safety component in a product that's already regulated by specific EU laws, these are listed in Annex I, and those existing laws require the third-party check for safety.
Okay, like elevators or certain medical devices.
Precisely. So if AI is controlling a critical safety function in those kinds of products, then the AI itself becomes high risk because it's integral to the safety of something already closely watched.
Makes sense. And the second way?
The second way is if it falls under the specific use cases listed in Annex III of the Act. These are areas where AI could have a really significant impact on people's lives and fundamental rights.
Right.
However, there's some important exceptions here too. An Annex III AI system might not be considered high risk if, say, it's only performing a very narrow procedural task,
Okay.
or if it's just improving the outcome of something a human has already done.
Okay.
Also, if it's just spotting patterns or deviations without actually replacing or influencing a human assessment, unless there's a proper human review later, it might be exempt.
So it doesn't make the final call, essentially.
Exactly. And finally, if it's only doing preparatory work for an assessment in one of those Annex III areas, it could also be considered lower risk. These exceptions are really trying to avoid putting unnecessary burdens on AI that has a limited impact.
Yeah. These exceptions seem designed to focus the regulations on the AI that's making the more significant or maybe more independent decisions in these high-stakes areas.
That's right. It's about targeting the regulation where it's most needed. Now, something really important to remember is that any AI system that profiles individuals is always considered high risk. No exceptions there.
Always high risk if it profiles. And just to be crystal clear, what does profiling mean in this context under the AI Act?
Yeah, good question. It refers to the automated processing of personal data, specifically to evaluate different aspects of someone's life. Things like their job performance, their financial situation, health, personal preferences, maybe their reliability, behavior, location, or movements. Basically, any AI building a detailed picture of you based on your data.
Okay, so if an AI is creating that kind of profile of you, it automatically jumps into the high-risk category.
Correct. And one more thing on classification. If a company developing an AI system thinks it falls under Annex III, but shouldn't be classified as high risk because of one of those exceptions we just talked about,
Yeah.
they have to document that whole assessment before they put it on the market or start using it.
Ah, okay. So the responsibility is definitely on the developers to justify why their Annex III AI isn't actually high risk. Now, for the AI systems that are classified as high risk, what kind of obligations do the developers, the providers actually have? It sounds like a lot.
There are quite a few, yes. First, they need to set up and maintain a risk management system that covers the entire life cycle of the AI, from design all the way through to when it's taken out of use.
Cradle to grave, basically.
Pretty much. They also have to ensure good data governance. That means the data used for training, validation, and testing the AI needs to be relevant, it needs to be representative of the real world, and as accurate and complete as possible for what the AI is supposed to do.
That makes sense. You can't build a reliable AI on, well, garbage data. What else is required?
They need to create detailed technical documentation that shows how their AI complies with the Act and gives authorities all the information they need to check that compliance.
Like showing their work.
Exactly. The AI system itself also has to be designed so that it keeps records, logs of relevant events, and any significant changes made to it over time, essentially an audit trail.
Okay.
And they need to provide really clear instructions for use to the people or organizations who will actually be deploying or using the AI. This helps those users understand how to use it properly and meet their own responsibilities under the Act.
Right, so everyone knows their part.
And crucially, high-risk AI systems must be designed to allow for effective human oversight. There should always be a human who can understand what the AI is doing and, importantly, intervene if necessary.
Human in the loop, or at least on the loop.
Exactly. The Act also requires these systems to achieve appropriate levels of accuracy, be robust against errors or attacks, and have strong cybersecurity measures built in. And finally, the developers need to establish a proper quality management system to make sure they consistently meet all these requirements.
That is a pretty comprehensive set of responsibilities. It sounds like building and deploying high-risk AI is going to require significant effort and investment.
It absolutely will.
Now, you mentioned Annex 3rd gives examples of these high-risk use cases. Could you
Yeah.
give us some more specific examples just to illustrate what kind of AI really falls into this category?
Sure, absolutely. We already touched on non-banned biometrics. So that includes things like remote biometric identification, except when it's just verifying your identity, like unlocking your phone. It also includes biometric categorization based on those sensitive attributes we discussed, and emotion recognition systems when they're used outside of the prohibited contexts.
Okay, so even if these aren't completely banned, using them often pushes the AI into the high-risk zone.
Precisely. Then we have critical infrastructure. This is a big one. It includes AI used as safety components in managing and operating essential services. Think digital networks, roads, water supply, gas, electricity. AI controlling these vital systems is clearly high risk.
Yeah, definitely.
In education and vocational training, AI systems that decide who gets access to schools or universities, or that assess learning outcomes, or maybe monitor students during exams, those are considered high risk because they can significantly impact people's futures.
Big life impacts there.
Huge. Then when it comes to employment, worker management, and access to self-employment, AI used for things like sifting resumes, making promotion or termination decisions, assigning tasks, or monitoring employee performance is also in a high-risk category. These decisions directly affect people's livelihood.
You can see why. What else?
Access to essential public and private services is another key area. This covers AI used by public authorities to determine eligibility for benefits, say, or AI used to assess creditworthiness.
Ah, credit scoring.
Though there's an exception specifically for systems intended purely for detecting fraud. It also includes AI used to evaluate emergency calls and even for risk assessment and pricing in insurance.
Wow, insurance too. These are services really crucial for people's well-being.
Absolutely. In law enforcement, several AI applications that aren't outright banned are still considered high risk. This includes AI used to assess someone's risk of becoming a victim of crime, things like polygraphs or similar tools, AI used to evaluate the reliability of evidence in an investigation,
Okay.
and AI used to assess the risk of someone reoffending unless it's solely based on profiling, which has its own rules. Even profiling during criminal investigations falls into this high-risk category.
Right.
Then, in migration, asylum, and border control, AI used for things like assessing risks related to irregular migration, examining applications for visas and asylum, and identifying individuals beyond just checking travel documents is high risk. Huge potential impact on people seeking refuge or crossing borders.
Definitely high stakes.
And finally, the administration of justice and democratic processes includes high-risk AI. This covers AI used potentially in legal research or interpreting the law, and also AI that could influence the outcome of elections or referenda, though it excludes tools that don't directly interact with voters, like maybe basic analytics.
Okay, that gives us a really clear picture of the kinds of AI applications the Act considers high risk and, well, why they warrant such careful regulation. It's all about potential impact.
Exactly.
Now, let's move on to the next level down. Limited risk AI systems. This sounds like maybe a lighter touch in terms of regulation.
It is much lighter. For AI systems in this category, the main focus is simply on transparency.
Transparency, how so?
The key requirement is that developers, and also those deploying these AI systems, they just have to make sure that end users know they are interacting with an AI.
Ah, okay. So if you're chatting with a customer service bot online, or maybe if you come across a deepfake video or image, you should be made aware that it's AI generated.
Exactly. It's about empowering users so they can make informed decisions about how they engage with the technology, letting them know what they're dealing with.
That seems pretty straightforward and important, especially with deepfakes becoming more common.
Definitely.
And then we have the final category, minimal risk AI systems. What falls into this bucket?
Well, the Act considers the vast majority of AI applications that are currently out there to be of minimal risk, and therefore they're largely unregulated by this specific Act.
So most AI we encounter day to day.
Probably. Examples often given include things like AI-enabled video games or maybe spam filters in your email. These are generally seen as having a pretty low potential for causing harm or infringing on rights.
Okay, so everyday AI that doesn't really pose significant threats to fundamental rights or safety. Right. Now, let's talk about something that's been getting a lot of attention recently, general purpose AI, or GPAI. This seems particularly important given the rapid progress we're seeing in things like large language models and other foundational AI tech. How does the Act actually define GPAI?
Yeah, it's a crucial part. The Act defines a GPAI model as an AI model, often trained on just a massive amount of data, frequently using self-supervision that shows a lot of general capability. It can perform a really wide variety of different tasks, regardless of how it's actually put on the market.
So it's versatile.
Highly versatile. And it's capable of being integrated into many different downstream AI systems or applications. Importantly, though, it specifically excludes models that are only used for research, development, and prototyping before they are released commercially.
Okay, so these are the really powerful, adaptable AI models that can form the basis for lots of different applications we might see. And a GPAI system is then what? Just an AI system built using one of these models.
Precisely. A GPI system is an AI system that's based on a GPII model, capable of serving various purposes either directly by itself or as a component of other AI systems.
Got it. And the Act acknowledges that these GPAI systems can definitely be used as or incorporated into those high-risk AI systems we talked about earlier.
Yes, absolutely. And it emphasizes that there needs to be good cooperation between the companies that create the GPI models, the foundation models, and those who develop the high-risk applications using them.
That makes sense. If a critical medical device uses a powerful GPAI model, both the model developer and the device maker have responsibilities, presumably?
That's the idea. They need to work together.
So, what are the obligations for all providers of GPAI models, regardless of how they might eventually be used? Are there baseline requirements?
Yes, there are several core obligations for everyone putting a GPAI model out there. First, they have to create comprehensive technical documentation. This needs to detail how the model was trained, how it was tested, and what the results of those evaluations were.
Okay, transparency again.
Very much so.
Yeah.
They also need to provide information and documentation to anyone who wants to use their GPI model to build their own AI systems, the downstream providers.
Why is that so important?
Well, it's crucial so that those downstream developers actually understand what the underlying model can and, maybe more importantly, can't do. This helps them make sure their own final systems comply with the AI Act.
Right, so it's about being upfront about the capabilities and limitations. What else is required for all GPAI models?
They have to have a policy in place to respect EU copyright law. This is obviously relevant given the huge amounts of data often used to train these models.
Yeah, the data sourcing is a big topic.
It is. And perhaps most significantly, they need to publish a detailed summary of the content that was used to train the GPAI model.
A summary of the training data. That sounds like a major step towards understanding what shapes these powerful AI. What kind of detail are we talking about?
The Act requires a sufficiently detailed summary. The specifics will likely be fleshed out further, perhaps in those codes of practice we might discuss, but the intent is clear more transparency about the data foundations.
Okay, now I understand there are some, let's say, lighter obligations for GPAI models that are released under free and open source licenses.
That's right. If a GPAI model is released under a free and open license, meaning its parameters, its architecture, how you can use it are all publicly available, allowing people to access, modify, and share it freely,
Yeah.
then the provider generally only has to comply with that copyright policy and publish the summary of the training data. The other documentation requirements are waived.
So significantly less burden for open source
Unless that open source model is considered systemic. That's the big caveat.
okay, the systemic designation again. What actually makes a GPAI model systemic under the Act? Is there a clear line?
There's a primary technical threshold defined in the Act. A GPAI model is presumed to be systemic if the total amount of computing power measured in floating point operations, or FLOPS, used to train it, was greater than 2025 FLOPS.
10 to the power of 25, that's an enormous amount of compute.
It is. It really targets the very largest, most resource-intensive models currently being developed. If a provider's model hits this mark, they have just 2 weeks to notify the European Commission.
Okay, so this is really aimed at the absolute cutting edge, the biggest players.
Primarily, yes. However, the Act also allows providers to argue that even if their model meets this huge compute threshold, it doesn't actually pose systemic risks based on specific characteristics or limitations.
So they can contest it.
They can present evidence, yes. And on the flip side, the Commission, either on its own initiative or based on a qualified alert from that scientific panel of independent experts.
Right, there's a scientific panel.
Yes. The Commission can decide that a model does have high-impact capabilities and should be designated as systemic, even if it doesn't meet that 125 FLOPS threshold, maybe based on its widespread use or specific potential impacts.
Interesting. So there's both a clear quantitative measure and a more qualitative impact-based assessment involved in deciding if a GPI model is systemic. It's not just about the compute.
Exactly. It provides some flexibility.
And if a model is ultimately deemed systemic, what extra obligations kick in for the provider?
Providers of GPAI models with systemic risk face several additional, quite demanding responsibilities. They need to conduct thorough model evaluations, including what's called adversarial testing, actively trying to break it, or find vulnerabilities to identify and mitigate potential systemic risks.
So really stress testing it.
Yes. They also have to actively assess and mitigate these possible systemic risks and understand where they might originate. It's an ongoing process.
This sounds like a much deeper, more continuous approach to managing the risks of the most powerful AI models.
It absolutely is. Furthermore, they're required to track, document, and report any serious incidents involving their model and any corrective actions they take to the new AI office and the relevant national authorities, and they have to do that without undue delay.
So quick reporting of problems is mandatory.
Yes, and finally, they must ensure that their models have an adequate level of cybersecurity protection against potential attacks or unauthorized access.
Okay. So for systemic GPAI, it's not just about being transparent like the others, but also about actively managing risks, ongoing testing, reporting problems quickly, and ensuring robust security. It's a whole different level of scrutiny.
It really is.
Now, the Act also mentions these codes of practice. What role do they play in all this, especially for GPAI?
Right, the codes of practice are intended to be a practical tool. They offer a way for GPAI model providers to demonstrate that they are meeting their obligations under the Act. If they voluntarily adhere to these codes once they're finalized, it creates a legal presumption that they are in compliance with the specific requirements covered by that code. It simplifies showing compliance.
Okay, so it's like a set of recognized best practices that if you follow them, you're generally considered okay.
That's a good way to put it. Now, providers who choose not to follow these codes aren't necessarily non-compliant, but they will need to demonstrate to the Commission through other means that they are meeting the rules adequately.
So the codes offer a clearer path, but alternative routes are possible. Who's involved in actually creating these codes of practice?
The AI office, which we should talk more about, can invite GPAI model providers and the relevant national authorities to participate in drafting them.
So industry and regulators working together.
Ideally, yes. And the process can also involve input from civil society groups, other industry representatives, academics, downstream providers who use these models, and independent experts. The goal is to get a wide range of perspectives.
Makes sense. And what will the codes actually cover?
They'll cover various aspects of the GPAI obligations. For instance, detailing what specific information needs to be in the technical documentation, methodologies for identifying and classifying systemic risks, and best practices for managing those risks effectively.
So practical, hands-on guidance. That sounds like a potentially useful, collaborative way to develop standards for the industry.
That's the hope.
Now, you mentioned the AI office. What about making sure all of this is actually enforced? Who's overseeing GPAI compliance specifically?
That's where the AI office comes in. The AI Act establishes this new body within the European Commission. Its job is specifically to monitor how effectively GPAI model providers are implementing the rules and whether they are complying.
So, a dedicated EU body watching over GPAI.
Exactly. And importantly, downstream providers, those using the GPAI models who believe that a GPAI model provider is violating the Act, can file a complaint directly with the AI office.
Okay, so there's a mechanism for raising concerns.
Yes. The AI office also has the authority to conduct evaluations of GPAI models itself. They might do this if the information they have isn't enough to assess compliance, or if they need to investigate potential systemic risks, especially if they get an alert from that scientific panel of independent experts.
So they have investigative powers too. It sounds like the AI office will be quite central to making the GPAI rules work in practice.
It will be absolutely critical, yes.
Okay, one last crucial piece, the timeline. When do all these different parts of the AI Act actually start to apply? When do these rules kick in after the Act formally enters into force?
Right, the application timelines are staggered, which is important for businesses to understand. The rules for the completely prohibited AI systems, the unacceptable risk category, those will start to apply relatively quickly, just 6 months after the Act enters into force.
6 months for the bans.
Yeah. Then for general purpose AI, the obligations we just discussed, those will begin to apply after 12 months, so 1 year.
A year for GPAI rules.
Yes. High-risk AI systems that fall under that Annex 3rd list of use cases will have a bit longer. They get a 24-month application period, so 2 years.
2 years for most high-risk AI.
Correct. And the longest time frame is for those high-risk AI systems that are components of products already regulated under Annex I laws. They get 36 months or 3 years to comply.
3 years for those integrated safety components. And the codes of practice for GPAI, when are they expected?
The Act sets a target for the codes of practice to be ready within 9 months after the Act enters into force. So fairly quickly to provide that guidance before the main GPAI rules fully apply at 12 months.
Okay, that's a really helpful overview of when different parts of this legislation will start to bite, essentially. So to kind of wrap things up and recap, the EU AI Act establishes this comprehensive, risk-based approach to regulating artificial intelligence across the European Union.
That's the core idea, yes, risk-based.
It outright bans AI systems considered to pose unacceptable risks to fundamental rights and safety. Then it sets out quite strict, detailed requirements for high-risk applications and their providers, things like risk management, data quality, human oversight, documentation.
A significant compliance burden for those high-risk systems.
Definitely. Then it introduces transparency obligations for AI classified as limited risk, basically, letting you know when you're interacting with AI.
Simple disclosure.
And it largely leaves minimal risk AI like spam filters or games unregulated by this act.
Right, focusing the effort where the risk is perceived to be greatest.
And crucially, it puts in place specific and quite evolving obligations for those developing these powerful general-purpose AI models, with even tougher rules for those deemed systemic based on compute power or impact.
Yeah, the GPAI rules are a really key forward-looking part of the legislation.
And it emphasizes things like cooperation between different players in the AI chain and the development of these codes of practice to help guide compliance.
Absolutely. It's trying to create a whole ecosystem of responsible AI development and deployment.
So hopefully this deep dive gives you, our listener, a solid foundation for understanding what is, well, a really significant and complex piece of legislation. It's definitely going to shape how AI is developed and used, not just in Europe, but likely influence regulations around the world too.
It's already having that effect, I think. It sets a benchmark.
So a final thought for you to maybe ponder. Considering all these different categories and the regulations we've discussed today, which aspects of the EU AI Act do you anticipate will have the most significant impact on the future of AI innovation and deployment? Will it be the bans, the strict rules for high risk, the GPA regulation?
Or perhaps the compliance costs or the enforcement mechanisms.
Exactly. And what questions do you still have about how this complex piece of legislation will actually be implemented in practice day to day? There are still details to be worked out. We definitely encourage you, if you're interested, to explore the official EU Artificial Intelligence Act documentation further to delve even deeper into this really important topic.